Imagine standing trial, facing serious charges and your defense isn't fully prepared. Key evidence is missed. Witnesses aren't called. Your lawyer's decisions could cost you your freedom, or worse. When defense fails, the consequences can be severe, and it happens more often than we like to admit. In this video, we'll break down what inadequate defense really means, why it matters, and how it has impacted real cases. Stay with us as we go back to the basics and uncover how fair representation can make all the difference in the fight for justice.
Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Among the many criticisms raised in the aftermath of the Lucy Letby trial is the allegation of inadequate defense. The claim that her legal team failed to properly protect her interest in court. But here is the crucial question. Is inadequate defense by itself enough to overturn a conviction in the Court of Appeal? Inadequate defense is a serious allegation, but it is not on its own an easy route to freedom. The courts set a high bar because every trial involves decisions, strategies, and risks. Only when those decisions fall outside the bounds of competence and strike at the heart of fairness will a conviction be overturned. Today, we are diving into inadequate defense as a ground of appeal. What it means, why it's important, and real cases where it has actually worked. If you're thinking about applying to the CCRC on this basis, this might give you some useful insights. And we will return to the Letby case later, so stay with us until then. But before we get started, a quick reminder, don't forget to subscribe, like and share. It helps us with our mission to humanize the criminal justice system. All right, let's start with the basics as we always do. When a person is convicted, the law provides one final safeguard, the right to appeal. Under the Criminal Appeal Act 1968, the Court of Appeal can quash a conviction if it considers the verdict unsafe. But as you know, appeals are not about re-arguing the facts, and that applies also to claims of inadequate defense, when the very lawyers trusted to protect the accused fail in their duty. One way a conviction becomes unsafe is if defense counsel falls so far below the standards of a reasonably competent advocate that the trial itself cannot be considered fair. So the answer to our original question, is inadequate defense by itself enough to overturn a conviction in the Court of Appeal, is not straightforward. The Court of Appeal does not quash convictions simply because mistakes were made or because another lawyer might have argued the case differently. To succeed, the appellant must prove two things. The defense's performance fell below the standard of a reasonably competent advocate, and that this failure undermined the fairness of the trial and rendered the conviction unsafe. So the court asks two questions. Did the defense's performance fall below the standard of competence? Did that failure make the conviction unsafe? Only if both are proven will the conviction be quashed. This was made clear in the case of Mr. Day in April 2003, a case that raised difficult questions about justice, legal representation, and the safety of criminal convictions. The case tested whether inadequate defense can ever be enough to overturn a murder conviction. Mark Day was convicted of murder in 1993 after a violent altercation led to the death of a man named Mr. French. He was sentenced to life imprisonment, and his first appeal in 1994 failed. Years later, the Criminal Cases Review Commission referred his case back to the Court of Appeal. Their concern? That Day's original defense may have been incompetent and that his conviction might therefore be unsafe. The appeal centered on three main criticisms: inadequate preparation by Day's legal team, failure to challenge key prosecution evidence, and the absence of character evidence that could have helped the jury see Day in a different light. The court had to decide whether these failings undermined the safety of the conviction. The judges acknowledged real shortcomings in Day's defense. Counsel had been instructed late, preparation was lacking, and some evidence was poorly handled. But the court ruled that these failings, while regrettable, were not enough to render the conviction unsafe. The court held that the prosecution's evidence was strong. Physical evidence such as handprint linking Day to the crime scene and the testimony of a key witness, Miss Tackwell. The court concluded that the jury's verdict would almost certainly have been the same regardless of the defense's errors. The appeal was therefore dismissed. This judgment followed the principle that appeals must focus on the safety of the conviction, not just on the competence of the lawyers. In short, poor lawyering is not enough. The failings must directly affect the fairness of the trial and the reliability of the verdict. The case of Day sets a high threshold for appeals based on inadequate defense. It reminds us that a conviction is only unsafe if errors could have led the jury to a different verdict. Dissatisfaction with the lawyer or even evidence of poor preparation will not be enough. For appellants, the lesson is clear. To overturn a conviction, you must not just show incompetence, but injustice. However, in a different case, the case of Adams, the Court of Appeal came to a very different conclusion. This was a highly complex gangland murder trial. Adams was convicted mainly on the testimony of an informant known as T, while another associate, H, had already been acquitted. Adams' first barrister, who had also represented H, had to step down because of conflict of interest, leaving the replacement counsel with just 5 days to prepare. The court accepted several criticisms. The conflict of interest should have been foreseen. The new counsel had inadequate preparation time, and crucial investigative work, such as reviewing the police database, resolving limited timing discrepancies, and probing the informant's arrangement with the police, was effectively not done. Although the court acknowledged the counsel acted in good faith, it concluded that the cumulative effect of insufficient preparation and late instruction rendered the conviction unsafe. This case contrasts sharply with Day, where the court minimized the significance of late preparation. In Adams, however, the judges showed a greater readiness to acknowledge how inadequate pretrial preparation can compromise fairness. It reinforces a point we have made many times before. Often the issue isn't strictly one of law, but of judicial culture and attitude. A simpler, more direct illustration of a successful inadequate defense claim is the case of James Hester. In July 1995, Hester was convicted of burglary and sentenced to 3.5 years in prison. The case was referred to the CCRC in 1997, which discovered that a crucial alibi witness had not been called despite Hester's clear instructions to his defense team. Further investigation revealed a breakdown in communication. The defense solicitors failed to notify or arrange for the witness to attend trial. At the time, the solicitor's practice was in disarray, and shortly afterwards the Law Society intervened and took control of it. Given these unusual circumstances, the CCRC concluded that the omission of this key witness was likely beyond Hester's control. The conviction was ultimately referred to the Court of Appeal and quashed. Now, turning again to the Letby case, was the defense mounted on her behalf genuinely adequate? The trial, as you know, was dominated by expert medical and statistical evidence. The prosecution argued that Letby was present at every unexplained collapse or death, and that air embolism and insulin poisoning explained many of the tragedies. But critics say the defense left these claims largely unchallenged in front of the jury. Several issues have since drawn intense criticism. Reports confirmed that Letby's lawyers had access to independent medical experts, but they were never called to testify. The jury only heard from the prosecution experts. Charts showing Letby on duty during every incident were presented as powerful proof of her guilt, yet statisticians have since called them misleading, and disclosure failures meant that the defense may not have had the full data at the time. The prosecution's air embolism theory rested on limited and decades-old research. Without their own experts on the stand, the defense struggled to persuade the jury the theory was speculative. Inadequate defense doesn't always mean the barrister was careless. It can also mean that the case was so complex that the defense needed more resources, more expertise, or simply a different strategy. When jurors hear only one side of the science, it's not surprised they accept it. If you don't challenge medical theories in court, they can quickly harden into fact. That's why not calling defense experts can be so significant. It can leave the jury with little reason to doubt the prosecution's interpretation. It is crucial, however, to bear in mind that some decisions, such as whether to call an expert witness, are generally left to the professional judgment of counsel. But in Letby's case, the pressing question is this: was the defense's approach a carefully considered strategic choice, or did it stem from misplaced confidence that the prosecution had failed to prove its case? Submitting a no case to answer application suggests that they believed the evidence was weak. Yet, if that was their stance, was it not a serious miscalculation to avoid building a stronger counter case, especially one supported by expert testimony? What may outwardly be described as strategy begins to look less like tactical judgment and more like overconfidence or even inadequate preparation. What do you think? Share your views in the comments below. These cases reveal a spectrum. At one end, serious failings that can lead directly to injustice. At the other, errors that, while regrettable, are not enough to overturn a conviction. The principle is clear. Inadequate defense is one of the gravest threats to justice, but proving it requires more than pointing out mistakes. It requires showing that the trial itself was unfair and the conviction unsafe. Inadequate defense is not just poor lawyering. It is a profound failure that can steal years of a person's freedom or even cost them their life. At its core, justice does not rest only on fair laws, but on the guarantee of fair and competent representation. Without it, the very foundation of our justice system begins to crack. If you found this video useful, please consider liking and sharing it. It really helps us continue our mission to humanize the criminal justice system. And of course, a final reminder, this is not legal advice. If you are affected by these issues, always seek guidance from a qualified legal practitioner. That concludes today's session. Join us again as we sit and rise in this unique trial.